definition of criminal conspiracy, punishment, and the provision under section 120A, explanation. These are all discussed in part 1 of the video. Now we will go to what are the ingredients required for the offense of conspiracy. For every criminal law, for every offense, there are ingredients. These ingredients are to be proved by the prosecution, then only the accused person will be convicted. So what are the ingredients required for the offense of criminal conspiracy? Only 3 ingredients. One is 2 or more persons, agreement, and agreement was to do illegal act or an act which is not illegal by illegal means. Only 3 ingredients have to be proved. 2 or more persons. What is the gist of the offense? What is required? What is the essential ingredient of criminal conspiracy? Agreement. Agreement is the gist of the offense. What is an agreement? According to contract, for agreement, minimum number required is 2. One is offer and other is acceptance. One alone cannot enter into an agreement. So in the same way, agreement is the gist of the offense for the conspiracy. Here also the minimum number required is 2. One person cannot conspire with oneself. So section starts with 2 or more persons. The minimum number required is 2 because agreement is the gist of the offense. What is the maximum limit? There is no entry. More, unlimited, depending upon the case. So 2 persons are required. But when you come to the under English law, husband and wife are treated as a single person. Husband and wife are treated as a single person. So if husband and wife enter into an agreement to kill X, it is not a conspiracy. It is not a conspiracy because husband and wife are treated as a single person. One person cannot conspire with oneself. So it is not a conspiracy. If the husband and wife enter into an agreement with X or Y, here husband and wife are one person and X is the other person. 2 persons are there. So conspiracy can be completed. But Indian law, husband and wife are not a single person. They are 2 different persons. So if the husband and wife entered into an agreement to kill X, conspiracy is completed. The bare agreement itself is sufficient because they are committing an offense. Murder is an offense. So the bare agreement itself is sufficient. So need not be entered into some third party because these 2 are 2 different persons. So they can enter into an agreement. And when only 2 persons are charged under section 120B, 2 persons were charged for criminal conspiracy under section 120B of the Indian Penal Code. 1 person was acquitted. 1 person was acquitted. Then the other person alone cannot be convicted for the conspiracy. 1 man cannot be convicted for conspiracy because the minimum number required for the offense of conspiracy is 2. So if 1 is acquitted, the 1 person cannot be convicted. So Topandas versus State of Bombay, 1956 Supreme Court. 4 persons were charged for the offense of conspiracy, out of which 3 persons were acquitted, which means criminal conspiracy was not established. 3 persons acquittal means there is no criminal conspiracy was established. There is no agreement. Then 1 person cannot be convicted for the offense of conspiracy. Bimbadar Pradhan versus State of Orissa, 1956 case, Supreme Court. Here the appellant, a government servant, he entered into an agreement with other 4 persons. What is their agreement? To misappropriate the government funds at their disposal. And they misappropriate the money. They misappropriated according to their agreement. Not only that, they have falsified the official records for their actions. They falsified the official record also for their action. Once one of the accused turned approver, and only 1 person was caught, and he was convicted for the offense of conspiracy. Here the Supreme Court draws a distinction between the Topandas case and Bimbadar Pradhan case. No conspiracy at all. The criminal conspiracy was not established by the prosecution. There was no criminal conspiracy. There was no agreement. 3 persons were acquitted. Clearly shows that there was no criminal conspiracy. There was no agreement. So one person alone cannot be convicted for criminal conspiracy. But in Bimbadar Pradhan case, criminal conspiracy was established. There was an agreement. It was proved by the prosecution beyond all reasonable doubt. But one turned into an approver, what other person may die, other person may abscond, only one person may caught. That person can be convicted for the offense of conspiracy. So the Supreme Court held that it is not essential that more than one person should be convicted of the offense of conspiracy. It is enough if the court is in a position to find that 2 or more persons were actually concerned in a criminal conspiracy. So if it is proved that 2 or more were engaged in the conspiracy, although they could not caught, one alone may be convicted. Although they could not caught all the other remaining accused, and if only one person was caught, the same one person can be convicted. Conviction is different. It is not the conviction of 2 or more. Once in the case, it is the prosecution has to establish the agreement between the parties. So there was a criminal conspiracy. Even though the others were not caught and only one person was caught, he can be convicted for the criminal conspiracies. And it is not necessary that all the members of the conspiracies must know the details of the conspiracy. Details of the conspiracies is not necessary to know by each and every conspirator. And it is not necessary that all the conspirators must do a single illegal act. Different persons will do the different acts. It is not a single, it is not possible to all the persons together to do a single illegal act. Different persons will do the different act. Similarly, it is not necessary that all the conspirators must join from the beginning of the agreement. Not necessary. From the beginning, not necessary. Different persons may join conspiracy at different times. So it is not necessary that all persons must join from the beginning of the conspiracy. Communication to all of the communication between all the members of the conspiracy is also not necessary. It is not possible. Conspiracy may start, for example, if you take Rajiv Gandhi, the then Prime Minister of India, murder's case. This scheme started in Sri Lanka. What they have discussed there, how they have planned, what is there, that the information is not known to those who are in the India. So it is not necessary also. The communication is not necessary. Actual participation is also not necessary. Full details of the conspiracy is not necessary. Doing a single illegal act by all the conspirators is not necessary. All persons must join from the beginning of the conspiracy is not necessary. Actual participation is not necessary. Then what is required? Design. Design must be common to all. They all enter into an agreement. So State of Himachal Pradesh versus Krishnalal Pradhan case, 1987, Supreme Court case. If pursuant to the criminal conspiracy, the conspirators must commit several offences. Then all of them will be liable for the offences. Even some of them had not actively participated. So here also the Supreme Court clearly held that active participation was not, even though the active participation was not there, all are equally guilty for the offence of conspiracy. What is required is agreement. The prosecution must establish that there is an agreement between all the persons. Then all these things are not necessary. All these things are not necessary. In Parliament attack case, the Supreme Court held that those who committed the offences pursuant to the conspiracy by indulging in various vote acts will be individually liable for those offences in addition to being liable for criminal conspiracies. So in addition to criminal conspiracies, the individual persons who entered into the agreement, who shared agreement, will do the different acts. So they are all liable, individually liable for the acts that they have done in addition to the conspiracy. In addition to the conspiracy. So very beginning we said that where there is an agreement to commit an offense, where agreement is sufficient. Suppose if A, B, C, D agreed to kill X, conspiracies and murder, for both offenses they are liable to be punishable. So in the same way, if the different individuals or the conspirators will do the different acts, they are all liable for their individual acts along with the criminal conspiracies. And the person who not actively participated in the crime, he is liable for the criminal conspiracy. But non-participant conspirators cannot be found guilty of the offense or offenses committed by the other conspirators. So non-participant conspirators is liable only for the criminal conspiracy. And he cannot be found guilty of the offense or offenses committed by other conspirators. There is hardly any application of the principle of agency. What is the principle of agency? Whatever the acts done by the agent, the principal is liable. Such rule is not applicable here, because in criminal law, mental element plays a very important. The individual, basing upon the individual mental element, the punishment will be fixed. Rajiv Gandhi assassination case, we all know that. And here, 4 persons were sentenced to the death, and later the Nalini in the April 2000, basing upon the basic recommendation of the state government, and also the former Congress President Rajiv Gandhi's widow Sonia Gandhi, they commuted death sentence to the life imprisonment. Similarly, they have commuted to the life imprisonment to other accusers also. Now, agreement, second ingredient. There should be an agreement. Without agreement, there is no conspiracy. Agreement is the gist of the offense. But agreement and intention is not the same. Agreement is not the intention. Agreement is an advancement of intention. Announcement and acceptance of intention is the agreement. Because this agreement generally, not generally, almost 100% they enter into secretly. Secrecy is an essential element for the agreement. So you will not get the direct evidence. And the agreement could not and need not be proved by the direct evidence. When you are not able to get the direct evidence, so the law also says that for the agreement need not be proved by the direct evidence. Need not or could not be proved by the direct evidence. Then how you will get the evidence? Direct evidence is not possible. Then participation in overt act by the conspirator. How they have participated? In the parliament attack case, all the 5 accused persons attacked the parliament and fired set there. Clearly shows that there is a conspiracy. There is an agreement. Their agreement is to attack the parliament. So participation, how they have participated in the overt act, is a good ground. So that we can draw the inference that they have entered in agreement. So the agreement can be proved by the participation of the accuser also. Participation of the accused. How he has participated in the crime is most important. The Supreme Court observed in Yadav case, state of Bihar, Paran Hans Yadav was the state of Bihar, 1987 Supreme Court case, that it is difficult the charge of conspiracy with direct evidence in every case. So direct, even Supreme Court says that direct evidence is not available for any criminal conspiracy. Then circumstantial evidence is to be collected. If the prosecution depends on the circumstantial evidence, a clear link has to be established. Link between all the, there are 10 circumstances. There should be a link between all the circumstances, and the chain has to be completed. This is what the Supreme Court says in Yadav case. So the direct evidence is not possible. The prosecution will depend on the circumstantial evidence, and there should be a clear link between the circumstances, and the chain has to be completed. Then agreement can be proved. In Ashok Datta and others versus state, 1979 case, it was held that the charge of criminal conspiracy being an independent offense. So criminal conspiracy is a substantive offense, independent offense. So it has to be proved just like any other offense. How the murder will be proved, how the theft will be proved, basing upon the ingredients. All the ingredients have to be established behind all reasonable doubt by the prosecution. Then the offense will be completed. In the same way, criminal conspiracy is also an independent offense. It has to be proved just like any other offense. So what is the required for the conspiracy? Agreement. So the prosecution has to establish that there was an agreement between the conspirators. And this has to be established with the prosecution beyond all reasonable doubt. So direct evidence is not possible. Direct evidence will not available because they enter the agreement into the secrecy. Then how prosecution will establish? Through the participation, only how the individuals have participated. What is the mode of participation of the individual in the design? That will give the clue that whether they have entered into an agreement or not. Say here I will give one example. Suppose a person has possessed a counterfeit coins machinery in their house. This machinery is used only for printing the counterfeit currency notes and none else. And that house was occupied by 3 or 4 persons. So it clearly shows that from these circumstances we can establish a link that all these 4 or 5 persons who are occupied in the house, who are staying in the house, had an agreement to cheat the public by printing the currency notes and distributing in the society. So now in this way, how the individuals have participated in the design, that will give the clue whether there is an agreement between them or not. In state of Tamil Nadu versus Nalini, this is popularly known as Rajiv Gandhi Association case, 1919, Supreme Court held that the association of the accused with the main accused and even knowledge about the conspiracy would not make the accused a conspirator. So A is associating with the main accused of the conspiracy. A has the knowledge about the conspiracy. Itself is not sufficient to convict him for the conspiracy. When he will be convicted? If he entered into an agreement with the main accused. He must enter into an agreement with the main accused. Then only he is liable for the conspiracy. Just association with the main accused, or just having the knowledge of the accused, or just giving a shelter in his house, these are all make him a liable for conspiracy. One has to establish the agreement. They have entered into the agreement, so he was associating with the main accused. He entered into an agreement, so he gave a shelter in his house. So this has to be established, then he is liable for the conspiracy. Just giving a shelter in his house, or just association with the main accused, or just having a knowledge about the conspiracy, they are not sufficient to convict a man for conspiracy. State NCT of Delhi versus Navjot Sandhu at the rate of Afzal Guru, 2005 Supreme Court case. Afzal Guru case was commonly known as Parliament attack case. Here 5 accused persons were found to be involved in the crime, and these terrorists enter into the Parliament house with sophisticated arms and powerful explosives when the Parliament was in a session. So these terrorists have inflicted heavy casualties on the securities men on the duty, and nearly 9 persons, including the Delhi police and security and a gardener also, were succumbed to the bullets of the terrorists were killed, the 9 persons. And even these 5 terrorists were also killed outside the Parliament. The Supreme Court observed that in most of the cases of the conspiracy, direct evidence of agreement is not available. In each and every case, the Supreme Court's first point is direct evidence is not available. The circumstances, if considered together, so only circumstantial evidence. If the direct evidence is not available, one has to depend on the circumstantial evidence. Considered together as they ought to be established beyond all reasonable doubt. The circumstances all together, taking some circumstances and leaving some circumstances, not like that. You have to collect all the circumstances together, and it has to be proved beyond all reasonable doubt that this fellow had entered into an agreement. So the same did in Afzal Guru case also. The prosecution succeeded in proving by taking all the circumstances together, and the prosecution proved the case beyond all reasonable doubt and said that Afzal Guru was a party to the conspiracy. He played an active role in various acts in furtherance of the conspiracy. And there is a close contact with the deceased terrorist. But he did not participate in actual attack. Short of participating in the actual attack, the Supreme Court felt that he did everything. He did everything, whatever the necessary, he did everything to set in motion the diabolic mission. So, thus confirmed the death sentence on Afzal Guru. What is an illegal act? Third ingredient. This already we have discussed in the part 1. Section 43 of the Indian Penal Code defines what is an illegal act. A thing which is an offense, 3 included in the 43. Section 43 included or described 3 things are illegal act. 43, definition of 43 of the Indian Penal Code says 3 things are illegal act. One is offense, second, a ground furnishing for the civil action, and third, prohibited act. If you read section 43 with 120A, 2 or more persons entered into an agreement to do an offense, 2 or more persons entered into an agreement to do a ground for civil action, or 2 or more persons entered into to do a prohibited act. Except for an offense, the provision says in the rest of the things, what act is necessary. Now, what is the word illegal has been given a comprehensive meaning under this section. It may include even the civil trespass. Civil trespass is also punishable as a criminal conspiracy when there is an agreement between the 2 or more persons to enter into some X house, criminal or X ground. Criminal. Suppose if they have agreed to do a civil trespass, it arises civil liability and also the criminal liability. Not only that, with respect to the breach of contract or wrongs of the independent of the contract committed by the individual along with the 2 or more persons after entering into an agreement. These are all covers under this section 120A. So this is civil liability, not only the civil liability, but it also gives the criminal charge of criminal conspiracy. Illegal means. What is an illegal means? Their agreement is to do legal act, lawful act. Suppose if any person enter into a lawful act or legal act, it is not an offense, it is not a wrong. A and B decided to marry, they enter into an agreement. Muslim law, for example, if you take marriage is a contract. Suppose if 2 parties enter into a contract that they want to do nikah or something, what the name nikah, I think, Muslim marriage, enter into a contract, that is a lawful act. So any contract enter into a lawful act is not an offense. Doing any lawful act is not an offense. But the means that they have adopted in achieving that object, A wants to marry B, okay, it is lawful act. But if the woman is not liking, she refused to marry him, taking away, that is kidnapping her and forcefully marrying, the means that they have adopted is wrong. Suppose if the person agreed with 3 or 4 persons, their agreement is to marry this lady, to marry this woman. So marrying is a legal act, but the way they are achieving the object was by illegal means, by kidnapping, unforceful marriage, etc. So that is punishable under this category. That is the illegal means. So agreement and 2 or more persons, illegal act, illegal means, these are the ingredients of section 120A, and the prosecution has to establish these grounds basing upon the circumstantial evidences, because direct evidence is not possible, and established beyond all reasonable doubt, then the conspirators will held guilty for the offense under section 120B of the Indian Penal Code.